Good morning. Sorry, we're going to have a few more minutes here until we get started. Projector is a lost cause. How much? An annual tuition. Okay. Well, nice to see everyone again. I had this, I thought, well thought out, slide I was going to show you that now I can't, and why I'm especially pissed about I was gonna tell you about the DC Circuit, and I was gonna have a picture of Supreme Court justices, and I was gonna hope that some of you would catch it, and that was all for Amy from last week, Tuesday. But they ruined my well-timed delivery. So, yeah, gotta love AV. No, they're trying. It's not their fault. Apparently, someone pushed this back and chopped the cord again. So anyway, so where are we? So today we're gonna really be diving into section 11. Today we're gonna try to get through a lot of dense material. So I'm just gonna be giving it to you kind of CLE style. So for those of you who are tired of policy and want to actually experience what you're gonna experience at a law firm, here you go. Here it is. All right. So one quick administrative comment. Office hours next week will be 1:30-ish, 1:15, 1:30. I have an admitted students event at 2:50, from 2:50 to 4:10. So I'll be out of my office in that window, but I'll just hang around for those of you who are free after that and would like to continue to talk. So I'll stay later on Wednesday. Okay, here we go. Section 11, BarChris, WorldCom. All right, remember, Section 11 imposes liability for any part of a registration statement that contains an untrue statement of a material fact or some omission required to make a statement about a material fact not misleading. So we are asking, what are the elements of Section 11 liability? So just to recap, Section 11 is a basis for liability for misstatements or omissions under the 1933 Act. And Section 11 is a non-mens rea statute. It does not impose any kind of intent requirement. A mere misstatement or omission is sufficient to trigger Section 11 liability. One of the things you need to keep in mind, both for the exam and for real life, is that there always needs to be some basis for bringing a lawsuit, right? It's not enough to just say that there's a violation of some substantive disclosure rule. That's what the Division of Corporation Finance can do, and did many times, and does all the time, with IPOs and other correspondence. The application of the law in the abstract, or even the application of a particular disclosure rule, is not the same thing as a procedural basis for bringing a civil claim. So Section 11 is one such basis on which you, as an investor, can sue. Particularly, you know that because it says, what? Any person acquiring such security in this Section 11A, I'm reading from Section 11A, thinking you see it, but you can't. Section 11A, any person acquiring such security may, either at law or in equity, in any court of competent jurisdiction, sue. So you have to start with some basis that allows you to bring a civil action. Section 11A is one such basis. Now, you saw in BarChris that there's a detailed, complicated, convoluted taxonomy regarding who is liable for what. And in true CLE style, I'm just going to give it to you, all right? So take notes, right? Or you just probably read this in the last, sort of following BarChris and WorldCom, there's just a nice taxonomy, and you could have just summarized it from there. But it's very simple, right? Issuers have no affirmative defenses whatsoever. The firm that issues stock under the 33 Act, and there is therefore found a material misstatement or omission in its registration statement, that firm is liable. Full stop. Okay? There are a few limited affirmative defenses we'll talk about. The key one, which I'll remind you of towards the end again, is that the plaintiff knew of the affirmative misstatement or the omission. But other than that, all right, basically, none of the due diligence machinery that we were talking about last class, or that expends, that fills up the pages of BarChris and WorldCom, none of that applies to issuers. So if you get a hypo, and this is like perfect multiple choice material, and this is really what you need to know in practice, and the question is the issue reliable for a material misstatement unless the fact is given that the plaintiff knew or should have known of the misstatement? The answer is yes, the issuer is liable. All right? This is really straightforward. Outside directors. Are outside directors of a firm liable? Directors who sit on the board of directors, individuals who sit on the board of directors who are not officers of the company. What do we learn from Bar-Chris and from the casebook? Outside directors can delegate their duty to monitor to some extent, but by and large, they're going to be held to a reasonably high standard. It's not as high as the standard that applies to inside directors, but outside directors, particularly those who have some kind of specialized knowledge. So often you'll have a lawyer as an outside director of your firm, and that lawyer will, in fact, be held to a standard, we saw this in the cases, to a standard that is higher than that of a director who lacked that kind of specialized knowledge. So you want to be looking out for something about these directors who, that might elevate their burden, and that is to say that if you have some kind of specialized knowledge, let's say, of the law, you might be held liable, or accounting, you might be held liable for misstatements or omissions that concern your area of specialized knowledge. You're going to refrain from using the word expertise, because as you saw, experts have their own special category. Inside directors, insiders, very high standard of due diligence. That is to say, if you're an inside director, all right, you've got to really show that you took a lot of steps to ferret out the truth, and nonetheless were sure at the end of the process that the facts in the registration statement were true. Now remember, just to reiterate, so we're all on the same page, Section 11 imposes liability for a material misstatement or omission. The only defense you have under Section 11, basically, by and large, is that of due diligence. Due diligence, the standard for due diligence, that's the reasonable grounds language that we read at the end of class, the standard for due diligence is going to vary depending on the actors who are involved. That's what we learned from Bar-Chris. All right? I am not going to go through all of Bar-Chris, but that's the bottom line. They go person, but the judge goes person by person, right? Each person is held to a slightly different standard with regard to the scope, differing scopes depending on the individual. Just to reiterate, issuers are going to be held liable for misstatements in the entire registration statement. So are inside directors, unless they're able to show due diligence with respect to the statement at issue, but that standard is going to be very exacting. We're going to need to see a very high level of due diligence, like they really asked every question they possibly could, and there were nonetheless no red flags, and there was still a material misstatement or omission. Outside directors have a lower standard. They can delegate their due diligence responsibilities, so they can claim an affirmative defense of due diligence without going through the exacting search that we demand of inside directors. But outside directors might be held to this higher standard if they have some kind of specialized knowledge. Okay, this is like Barbary. Okay, this is just a set of rules you need to know. Underwriters. Underwriters are what? Underwriters are, as a matter of first principles, liable for misstatements or omissions under Section 11. So Section 11 is very broad. It sweeps in issuers and underwriters. Who does it not sweep in? Sorry? Brokers. Does Section 11 sweep in brokers? What's that? Does everyone agree that Section 11 does not sweep in brokers? Yeah, that's right. Section 11 does not sweep in broker-dealers. Well, there's another, there are other places you can get the brokers. But yeah, by and large, Section 11 goes as far as underwriters. By and large. And there are some interesting fact patterns concerning like underwriter syndicates, groups of underwriters, and so forth. But yeah. All right. Remember, we're in the primary market here. We're looking at the 33 Act. We're talking about IPOs. We're talking about capital being issued. And so the standard story here involves a firm issuing equity that the underwriters are essentially reselling to the general public, okay, or to the first buyer other than themselves. So the idea that you would hold a broker or dealer liable for in this particular chain of sale is a little strange, and that's the rationale behind Section 11, that we're going to look to those who were involved in the chain of sale of the firm's equity. Sort of, right? You're going to see in Section 12 that the idea of a chain of sale is really much more predominant there, but it's still sort of underlying Section 11, all right? Now, what about underwriters? So underwriters have a due diligence defense for what? For non-expertise portions of the registration statement. What's an expertise portion? An expertise portion, this is like, you know, people say they're learning SecReg, like this is what they learn, right? So an expertise portion of the registration statement is the portion of the registration statement which an expert has attested to its truth or certified that to the best of their knowledge and reasonable efforts and so forth and so on, it's true. So underwriters, as to non-expertise portions, have a due diligence defense. They need to show that they conducted due diligence for non-expertise portions of the registration statement. What about for expertise portions? They have a safe harbor, right? So the underwriter cannot not even look at expertise portions of the registration statement, right? Not even worry about expertise portions of the registration statement, right? Do you agree? Did you read WorldCom? No. So even though the rule is that underwriters have the privilege of relying on experts for the expertise portion of the registration statement, it turns out that they still need to go undertake some kind of reasonable investigation of red flags that might pop up. Or if they kind of know that the accountants aren't really doing their job, the underwriter has an additional duty to kind of, sort of, it's not exactly clear what this standard really means from WorldCom, but they've got to do something more than just close their eyes and rely on the expert. All right? Multiple choice question, 1G on the exam. I don't know. Are issuers subject to are issuers entitled to close their eyes and rely on experts and thereby avoid liability for the expertise portions of a registration statement without conducting due diligence? Who thinks yes? Issuers, like underwriters, can rely on experts for the expertise portions of a registration statement. Who thinks no? Right, why? No due diligence defense for issuers, right? No due diligence defense for issuers. No defenses whatsoever, basically, for issuers. What about outside, non-specialized outside directors? So Susan is a successful investor, owner of many, many companies, and sits on the board of Blackacre Inc. Susan, Blackacre Inc. is about to, is issuing equity, issues equity. Susan reviews the registration statement and sees a section of the registration statement concerning the financial performance of the firm that has been attested to or certified by KPMG, a well-known accounting firm. Susan has some doubts, though, when she looks at the numbers. She's not sure that those numbers are right. She thinks they look kind of inflated, but there's an audited accounting firm that has signed off on those numbers. Susan is a director. She's an investor. She's not a specialized director in that she's not a lawyer or an accountant. Is Susan entitled to rely on the expertise portion of the registration statement and not conduct any further investigation? Who says yes? like, who says no? Oh, most of you aren't voting. All right, someone give me a reason yes. Who thinks yes? Sam, do you think yes? No, you don't think yes. Does anyone think yes? Inside director, outside director, non-specialist. Okay, why not? So you're on the yes side, that she's entitled to rely. I think I'm with Magdalena. Does anyone disagree? Yeah.
I don't know. So under Section 11, the idea is that you have no reasonable, you only can claim the expertise section defense if you have no reasonable ground to believe that the statements were untrue. And so here, this seems like one of those red flags where maybe she has to do a little more to at least reassure herself that there's no reasonable ground to believe that they're
an
not
underwriter
true.
certainly would under WorldCom. But WorldCom hasn't been, maybe, I don't know, maybe it has been recently, but to the best of my knowledge, WorldCom hasn't been extended to outside directors. So you could make an argument that it should be, but it's not clear to me. If what is reasonable, well, a reasonable reasonable grounds to believe. Well, I mean, if I see an accounting firm sign off on the number and I think they have 100 accountants, I don't know. I mean, my intuition is that that's probably like Magdalena. I think I'm in that camp. I think that's pretty reasonable to rely on that. Now, the underwriter is held to this heightened standard in WorldCom, in part because there's a sense that the underwriter is sort of tasked with not misleading the market, right? There's this sense that the underwriter is this gatekeeper. That's Jack Coffey has this great book on this, that intermediaries like underwriters are gatekeepers. They're reputational brokers, essentially standing in for an unknown issuer and holding themselves out there as being reliable for the investing public to count on. And this was really a big concern in WorldCom. Now, can you go that far and say, well, maybe we should start having all outside directors question accounting certifications? It's a tough one. Probably wouldn't be a multiple choice. But it might. I don't know. No, then that wouldn't be fair. So that's a hard one. That's a hard one. That wouldn't be fair. But yeah, that's not clear. Okay, experts. Experts liable only for the portions that they are certifying, attesting to their expertise, right? So accountants are not, liable for misstatements in other parts of the registration statement other than the part that they certified, the financial statement. What about lawyers? There was a question on Tuesday about lawyers. Are lawyers experts? Who thinks lawyers are experts based on the reading? Who thinks lawyers are experts? Lawyer, Michael, you agree? A legal sign-off, that kind of makes them experts. Are they liable then? Who thinks that lawyers are liable for the entire registration statement? Any misstatement on the entire registration statement? Did you read Bar, Chris? Yes. Right, so our inside directors, or outside directors more commonly, outside directors can be lawyers, and thus the burden will be heightened, but that is different from the lawyer who signed the registration, so gave some legal certification to the registration statement. What happened to the lawyer in Bar, Chris? Should we look? All right, let's look. So back to Bar, Chris. Since one of you asked about lawyers, I thought we might as well, since you should know. Well, actually, it's on 983. I can just do this faster. Page 983. An attorney provides a legal opinion used in connection with a registration statement is an expert within the meaning of Section 11. Michael got it. Excellent. All right, you all see that? Attorneys who are not acting as experts in the preparation of the registration statement are not liable under Section 11. All right, so you need some kind of legal opinion being prepared, and that was what happened in Barker's. Okay, what's the standard of investigation that an expert is held to? Who knows? Spit it out. Experts are held to what? Yes, Christian.
They're generally acceptable practices.
Excellent. Yep. Practice is generally considered appropriate in the profession. Okay? So an expert who fails to do their job, to investigate, an accountant who fails to investigate the numbers, an expert who fails to perform their expert duties in a manner generally considered appropriate in the profession is liable for misstatements or omissions in their expertise portion. What about misstatements or omissions in your expertise portion if you can show as an expert that you conducted an investigation according to standards generally considered appropriate in your profession? Are you completely off the hook? No. Right? The Simon and the Monroe cases mentioned in the casebook, if the standards in your, at least in the, I believe the Second Circuit, at least if the standards of your profession are too lax, it might be that nonetheless, you are in trouble. He just keeps going. This is like CLE. All right, here we go. Non-expert defendants for expertise portions of the registration statement. Liable? Who thinks liable? No, right? You're entitled to rely on the expert. Unless, what? What's the caveat? Remembers from Bar Chris. Yep. Okay. Great. Excellent. If you knew or should have known that the expertise portion was false, you're back on the hook again. We're doing 1 day of this. All right? But you got to get it. This is like, you know, they won't believe you took SecReg if you don't know this stuff. All right. What about Rule 176? Why is that not helpful for underwriters? What was going on in WorldCom? Yep, Mariah? Yep. And so what happened with Rule 176? Why was it not helpful for them? Does everyone have Rule 176? Right. Great. So Rule 176, in determining whether or not the conduct of a person constitutes a reasonable investigation or reasonable ground for belief meeting the standards set forth in 11C, relevant circumstances include the type of issuer, the type of security, the type of person, the office held when the person is an officer, the presence or absence of another relationship to the issuer, or reasonable reliance on officers, employees, and others' duties whose duties should have given them knowledge of the particular fact. So, Rule 176 is always going to come up when you're trying to evaluate a reasonable investigation or reasonable grounds for belief. The problem is, you're always going to have this problem of what is reasonable reliance on officers, employees, and others whose duties should have given you knowledge. Of course, as you know by now, I think all this is just, not very helpful in terms of actually guiding behavior. The point of this is to know what the law is and to have sort of a sense for why there's such an extensive due diligence process around IPOs, right? That's because underwriters are in trouble, particularly after WorldCom, if they just try to say, well, we relied on representations that were made to us by the firm. Okay? So when you're investigating the non-expertise portions of the registration statement, you need to look really hard if you're an underwriter. Remember, underwriters do deals like these all the time. This isn't about one issuer. This is like you get sued if you're Goldman Sachs. All right? So the pockets are very deep. This isn't some crappy startup that might not be around and so nobody cares. This is like really important. And if you, to Goldman or JP or Citi, if you work like I did on some of these deal teams, like that's what they're worried about. That's why they're paying $1,500 an hour to a partner, okay, to run a due diligence effort that you will probably supervise, right? Because of these standards. So this has created the economic demand for your services, post-graduation employment, thanks to Section 11. Okay, all defendants under Section 11 have a defense that the plaintiff knew of the untruth or omission. Let's just review the elements of Section 11 liability one last time. You must identify, like this is what you write in an exam, right? A material misstatement or omission. The omission standard is a very tricky one. Whether it was a great question via email, how do we distinguish between omissions here and omissions that are giving rise to 10b-5 liability in the duty to update or duty to correct setting? Well, here, you've got to identify a misstatement or omission within the four corners of the registration statement. So there we were talking about projections and what might change, if how you might need to update the market if there's been a change in the information you had at the time of the projection. But here, we could be talking about present facts, like we have the following patents. We have the following IP. It's not a statement about the future. It's not a projection. It's not a forward-looking statement. It's a statement about the present or the past. And that statement is either true or false. If it's false, it's a material misstatement. It can be true, but nonetheless misleading. For example, we have 10 issued patents. But if you don't tell your investors that you have 1,000 lawsuits over those, or that you have, maybe more importantly, that there was an adverse decision that could invalidate the basis for all of those 10 patents, that is a material omission at the time of the prospectus. This is not, this is not a Time Warner, right? Or, this is not even, this is nothing to do with the future. This has nothing to do with a projection. This is a fact. The fact is we have the following assets. But if I don't tell you that those assets might be subject to substantial legal risk, that could be an omission that makes those facts misleading. Yes?
Joe.
Yeah.
Yeah, just to be clear, something could be the basis of both kinds of liability, right? Like if you don't know about something in the present because of a failure to investigate, and then later it's found that you didn't update the market or correct about it. Like the same fact could be the basis of both kinds of liability.
Yes.
Okay.
But you would generally prefer to bring your claim under Section 11. Why? Does anyone know who read ahead? Nobody? Yes. Yes. Paul? Yeah. You were sitting on a switch. Why am I not surprised? Okay. You should be unhappy because it's your tuition dollars. Anyway, all right. So, right. So there's no scienter. There's no mens rea requirement. So you would always prefer to bring the claim under Section 11. Okay? And so that's why, while it's true, Joe, that you can try to loop in a duty to update violation of the duty to update under 10b-5 later on, and say basically the firm is allowing a bunch of trading in its securities, or even insiders might be trading. You can come up with all kinds of post-registration statement theories for liability. It's much easier to establish a Section 11 claim for violation of for an affirmative misstatement or omission in the prospectus itself. Okay. The elements. Misstatement or omission. Material fact that the plaintiff did not know, and there is no due diligence defense available. Are there questions on the elements of Section 11 liability? Yes.
if an issuer is going to use that defense that basically the plaintiff already knew, is that like, so you're not considering that an affirmative defense because it's disproving one of the elements that they would have to prove anyway, or like, is that an affirmative defense? Like, how do you view that?
So the question is, what is your name?
Sorry, Carly.
Carly. Yes, Carly. I remember that. So Carly asks, is the fact that the plaintiff did not know an affirmative defense, or is it an element of establishing liability that the plaintiff did? Is that your question? So how would we formally characterize it?
But if the issuer goes that route, that's what they're going to try to prove to get off the hook, is that considered an affirmative defense, or is they're basically just rebutting one of the elements that the plaintiff would have had to prove anyway?
So if you can show that the plaintiff knew of the misstatement, I think of that as, I mean, I guess you could think of it as a defense, but that would be very unusual, right? I mean, it would be very unusual where you had to have evidence that the plaintiff knew or should have known, because the plaintiff is usually a purchaser, right? So the idea that a purchaser is hanging out, sort of buying the stock, while telling, there's some sort of recorded conversation, right, with their friend. Yes, I know that those sales figures are complete nonsense, but I'm nonetheless, I know they basically, cooked the books, but I'm nonetheless buying the stock, strikes me as an unusual fact pattern, right? Like, you'd have to really stretch it. Maybe that should have known prong could be used in particular, but I think it would be hard. That's a hard defense to establish. The due diligence defense for a non-issuer defendant is, in fact, much, much more contested, right? So there, the claim, and this is in many ways really the last backstop to Section 11 liability, right? Because Section 11 imposes strict liability, because there's no scienter requirement, no mens rea requirement, really, and because it's almost impossible to prove that a plaintiff knew of the misrepresentation, the last sort of, backstop to liability for the misstatement is due diligence. But who cannot claim a due diligence defense? Should be automatic now. Issuers. So what do issuers do? Does anyone know? What's that? Forward-looking statement? Right, so if I have forward-looking statements, I have a safe harbor. So that's good. But Section 11 is going to concern misstatements that are about present facts. So what my sales were. So what do you do if you're an issuer and you do not have a due diligence defense available, because you don't? You can't make everything in your prospectus forward-looking. What can you do, Andrew? Yeah, so one thing you can do is basically claim no facts, right? So you can say this is what we believe to be true. That may or may not work very well, right? The market may or may not like that. Yeah, any other ideas what you can do if you're an issuer? Yes. Dylan? Yeah. Buy insurance, right? That's what I would do. Litigation insurance. What are those policies called? Is it litigation insurance? Anyway, there's D&O coverage, but this is not D&O liability. So yeah, I would buy insurance. One problem is, though, what's the problem with buying insurance? There is a problem with buying insurance. Yes? Christelle? Christelle? Yeah. Great. What message does it send? That you're lying, right? Great, Christelle. Excellent. So who is going to really care about that message? Your investors, but someone else. Who? Underwriters, someone else. More important. More important. Insurance company, right? So who wants to sell insurance? This is lying insurance. Okay. I'm going to sell you lying insurance. What price should I sell you lying insurance at? I mean, so this is a problem, right? So this risk, unlike other risks that we've discussed, excuse me, involves private information, right? So private information that issuers have is, in fact, a very difficult risk to insure against. Because so suppose there are two kinds of issuers. There's the lying issuers and the truth-telling issuers. Who will buy insurance? The lying issuers. So it's not that, in fact, your demand for insurance is the same regardless of the information you have. Does everyone see that? It's not the same. That is, it's not just risk spreading. Insurance in this setting involves information that you know as an issuer. So one little bit of sort of rationale you might insert to the Section 11 regime is that Section 11 imposes liability in a case, in a setting, strict liability, in a setting where we think it's most needed as a deterrent and that parties are unlikely to buy insurance for, to be unlikely to be able to buy insurance. Does everyone see that? If you are an underwriter, you can think of the risk that you miss something in due diligence as kind of like a coin flip. You just can't resist treating you like Columbia law students, all right? So just can't resist it. So think about that. So there's some risk that you miss some facts. And some of the time, you're going to, basically be wrong. In some proportion of the time, you're going to have all the information in front of you, and you're not going to need insurance. So what do you do as an underwriter? Well, you could buy insurance so that you're not exposed to those risks, because those risks, you would think, are largely outside of your control. Because after all, it's the issuer's business we're talking about. The issuer, on the other hand, never faces coin flip-like risk regarding bad information. The issuer should know in any particular case whether or not they're lying. After all, they are the issuer. Does this make sense? So the risk that an underwriter faces is akin to a coin flip. It's actually normal risk. It's like the risk of investing, finding out that you bought something that was worth less than you paid for it. This overpayment, underpayment problem. Issuers are not facing a kind of overpayment, underpayment problem. So one way to rationalize the Section 11 regime is to say, look, there's a strict liability with no due diligence defense for issuers because we want to induce them to ferret out the facts, to use their private information in a way that benefits investors. We don't want to let them get by not telling the truth. But underwriters, we think their access to the truth is likely to be as good as a coin flip. They may discover the truth in any particular setting, any particular IPO, or they may miss some facts. And that's why their risk is lower, and we're more likely to find a kind of insurance where you might think of the safe harbor here as a sort of legal insurance. Okay, damages. 11G, they're capped at the stock price, right? So if it turns out that the stock price increases after the misstatement, you cannot recover under Section 11 the difference between the offering price and the subsequent price of the firm's stock. So the offering price serves effectively as a kind of cap on damages. Causation. There's no formal causation requirement, but 11E, let's look at 11E, gives us a kind of reverse causation, or negative causation, as the textbook calls it. So let's look at 11e. All right. The suit authorized under subsection A may be to recover such damages as shall represent the difference between the amount paid for the security not exceeding the price at which the security was offered to the public, just said that, and the value thereof at such time suit was brought, or more stuff, provided that if the defendant proves that any portion or all of such damages represents other than the depreciation in value of such security resulting from such part of the registration statement with respect to which his liability is asserted, such portion of all or such damages shall not be recoverable. Does everyone understand what this is doing? Nod your heads if this is clear. No, shaking your head. This is not clear. Basically, so let's just walk through the setting, because this is, I think, important to understand. On Monday, the registration statement is filed or declared effective immediately, doesn't matter. There's a misstatement. The stock price is $10 on Monday. On Tuesday, you buy. The stock price is still $10. On Wednesday, you realize that there was a misstatement, a material misstatement in the registration statement. The value of the firm is, in your view, as a result, $5 instead of $10. It's worth half of what you paid for it. You're upset. You paid $10 for something worth $5. You sue the company. The company says, wait a minute, on Tuesday when you bought the stock, we told the market that if, something happened in the intervening period, our company would be worth less. And it turns out that something did happen. Someone won an election. Who knows? Something happened on Tuesday, something else. And that thing explains why our company is worth less. So the defendant can articulate another cause. The defendant can articulate another story that led to the stock price to fall. Now, if the defendant succeeds in doing that, if the defendant proves that the damages are not driven by the depreciation from the misstatement or the omission, but rather from something else going on, off the hook. Is this clear? So you don't need to prove as a plaintiff causation in the typical sense that, I would not have bought the security but for the misstatement. I would not have bought the security at that price or whatever. You need not establish that sort of affirmative causation, but rather you get a sort of presumption of causation as a plaintiff if there's a misstatement or omission in violation of Section 11, and it's on the defendant to argue, to show, that there was some other basis for the damages that you're claiming, some other basis for the stock price decline. Questions on the formal elements? Oh, one more formal element of Section 11 before we leave Section, well, we're not leaving Section 11, probably never, not today at least. Who can sue under Section 11? Can you only sue if you bought at the IPO under Section 11? No. Any purchaser, right? Hertzberg case. Okay, questions? Is this clear? These are the elements. Yes, Michael? Nice. A good way to connect the course material. So Michael says maybe IPO underpricing is driven by the strict liability regime under Section 11 that applies to issuers. So let's just think about that for a second. So IPO underpricing means that companies worth $10 are only getting $9. Buyers are only willing to pay $9 for something worth $10. How would that be driven by the imposition of liability that reduces the profit to the firm from the IPO? There's some chance you're going to be liable. That's going to reduce your profit. So that company might be worth less. So you're saying it might be worth less, and all that's happening, you're basically, I guess, arguing there's no underpricing. Because if it's worth $9, because that dollar is essentially a litigation cost, right? But the empirical evidence on IPO underpricing is driven by the fact that the stock price seems to rise after the IPO. So is there a story, can you think of one, whereby the imposition of legal liability can explain why the price is too low to begin with? Okay, let me walk through that. So you're focusing on the asymmetric treatment of damages under Section 11, and you're saying if the price rose. If the price rose, so the discussion of the price rising is in the following setting. We have our $10 company, the price goes up to $12 and then falls to $5. And the question is, do you get the delta between 12 and 5 or the delta between 10 and 5? Right? And so the statute provides that you only get the difference between the price, between the 10 and 5, right? Between the price at which it was offered to the public, the security was offered to the public. But that doesn't, I guess you could be saying, well, it could, I'm not sure I fully see it, right? So it could, that subsequent decline is the IPO underpricing bubble problem, right? That they seem to rise and then fall, so they seem to be too low to begin with. How could that be driven by Section 11 liability? Can you articulate it a little more? We can talk after, yeah. But it's a nice idea. Yeah, Magdalena. That makes sense, right? Exactly. So this could be the underwriters. So in this story, right? So it's okay, great. So underwriters want to capture that gap. Okay, now I'm with you. Yeah. So underwriters might want to keep the difference between the true value and the price they're selling it at, and the price they buy it at from the value they can sell it at is going to be a lot higher than the value they'll buy it at from the company, because they want to pocket the difference to compensate them for Section 11 liability. That could be. Right, that could be. So if we think of IPO underpricing as a phenomenon driven by underwriters mispricing offerings, yes. Does everyone see that? But we were talking about issuers, so it's not exactly the same, right? But the strict liability for issuers is a tougher one, I think, to rationalize. I think you have to really tell a story of private information held by those issuers. Other questions or comments? Yes?
Now, when defendants want to...
Can you tell me your name? Tom, there you are, yeah.
So when defendants want to rebut the presumption of causation, what's the burden of evidence there? Is it a reasonable explanation, or do they need to provide a relatively detailed event study?
I don't know. Typically, to prove causation in securities litigation, you need to run an event study. The question is here, yeah, I guess you'd probably need to run an event study on the confounding event, right? So there's some other event that happened that affected the price negatively. So you might need to run an event study on that. The question is, could you really show via that event study that the initial misstatement had no effect? Or could you quantify the effect, as it says, provided that if the defendant proves that any portion or all of such damages represents other than the depreciation in value. So is there some portion that you can, in fact, link to the other event and then subtract from the damages calculation? That might be, so it might be that you can't completely reject Section 11 liability on the basis of an event study, so on a confounding event, but you could quantify some portion of the decline in the stock price and then deduct that essentially from the damage calculation. That's my best guess. Yeah. Other questions? Yes. Tim.
I guess I was wondering what the policy rationale is for the damages being capped at the offering price, or the difference between the later price and the offering price. Because it seems from an investor protection standpoint, if you bought higher than the offering price and then went down, say 50%, but still above the offering price, you've lost a lot. And then from a sort of discouraging companies from making misstatements perspective, it doesn't make sense to only discourage those misstatements, which then drive the price below the offering price rather than just down a lot.
So the asymmetry of the treatment of these two is bothering you. Yeah, I think it's an interesting question. Why? Well, so one immediate answer is that the concern. So we're in a setting where a company is selling equity stock to raise capital. Therefore, we shouldn't be in a short sale world. Everyone should be going long, if you will, buying the stock, because that's what the IPO is. It's an infusion of capital into the firm, right, to fund projects. So it is a one-way transaction, a purchase. Now the question is, okay, so could there be damages in a buy setting, in a purchase setting, where the stock price goes up? What kind of damages would those look like? Well, you're better off as a purchaser in that case. So the question is, the stories here revolve around, can I use some other price, like not the offering price, but some subsequent price to basically increase my damages, right? So it's not that liability here or damages here are ever going to arise when the stock price increases because you bought. At least that's the assumption. I mean, we're in the IPO world, right? But could it be that we would still want to give you the difference between the price that you paid, which could be higher than the offering price, and the ultimate price at which the stock ended up? I mean, can you articulate, or someone else, a reason why it makes sense to give you a larger damage award here? Yeah.
Well, yeah, I mean, I think you could justify it in two ways. Number one, if we just want to go back to the sort of classic investor protection rationale, then you should sort of be able to rely on the fact that the initial offering statement or the registration statement is truthful, and then if it turns out not to be truthful and that negatively impacts, the stock that you own, then you should just be compensated for that. And also from a perspective, I think that probably the stronger rationale is from the perspective of just discouraging misstatements generally. If you're a company and you think, well, in general, our price is going to go up, so maybe we don't need to be too careful because we're not actually going to have to end up paying any damages on a potential misstatement, that could also be a problem that you'd solve by allowing further damages.
Right. So, but remember, right, no, that does make sense. Particularly your last one makes the most sense to me. Remember, though, Section 11 liability is supposed to be, at least the theory is, tied very fundamentally to the registration statement. I mean, the material misstatement or omission has to be in the registration statement. So if you offer the stock at a particular amount, you might say, well, this is Magdalena's point, that underwriters are systematically lowering the price, and so therefore the offering price kind of artificially depresses. And I think this is to connect your two comments. You might say, well, the offering price is artificially depressed because of underpricing, and that's the harm that's accruing to investors. But remember, the price at which the securities are offered in the IPO is the cap. And that is the statement on the basis of which the theory is, purchase the stock. So you've got to be able to articulate a story that protecting investors means giving them the benefit of subsequent appreciation in the value of the stock that wasn't tied to the registration statement, at least not in time, because it had to have happened after the offering, the appreciation. So maybe the story is, and this is kind of creative, and I like it, which is like, maybe the story is, yeah, the reason why you want to give them that appreciation, why they deserve it, is because underwriters are systematically mispricing them down. And so the idea that the offering price is somehow the true transaction price is a fiction. That's a version of this that I think is convincing, right? Which is really to link to Magdalena's point. But you'd have to articulate some reason why the offering price is not a good indicator of like the harm, the sort of upper limit of the harm that the investor suffered from the registration statement. And the only possible story is that it must be that on average, these prices are systematically lower than what they should be. Right? That's the story that I can see. But it doesn't follow automatically just because there's some future increase in the price of the stock, that liability for a misstatement on the registration statement. That's the key point. Remember, if we were in a duty to update world, a duty to correct world, and we're talking about 10b-5 liability, then it would make total sense to look at a subsequent price. But here, we're not. Here we're talking solely about the registration statement itself. Yes? Eugene, yes. Great. Great. So Yuchen says maybe the rationale is that we just want Section 11 limited to misstatements made on the prospectus, the registration statement, and the registration statement, liability for misstatements made on the registration statement is not the only basis for securities liability, right? For civil liability under the securities laws. We have another regime. We have the 10b-5 regime. The problem is, going back to Magdalena's point, and Michael made this point too, which is that you really need to establish under 10b-5 some other basis for bringing a claim. You need some other misstatement or omission subsequent to the registration statement. And if the story is that the price of the registration statement is just artificially, the price of the offering, the initial price is just artificially depressed, then in fact, it's not clear that any such bases would exist, because all you're saying is underwriters just on average price IPOs too low, and it's not that the depression in the price thereafter is somehow attributable to a subsequent misstatement under 10b-5. Yeah, you could try maybe to pin the liability here on a direct violation of 10b-5 at the moment of the, but again, you'd have to establish a scienter or a mens rea, which is going to be very hard. So it's actually a kind of a fun puzzle. I didn't think about that one, but that's a good one. Yeah, I like that one. Other comments or questions? All right, a little bit more on Section 11, Omnicare. So Omnicare is a D.C. Circuit opinion, right? You guys. All right. Is Omnicare a D.C. Circuit opinion? You're all too tired. It's Thursday afternoon. All right. Omnicare is, in fact, not a D.C. Circuit opinion. Amy, I'm never forgiving you for that. I'm just kidding. You actually get extra points. That was great. All right. So what's going on in Omnicare? So the question here in Omnicare is, in fact, whether statements of opinion, that is, I believe, are the kinds of facts that can give rise to Section 11 liability. I believe we are the best widget manufacturer in the world. I believe that we had sales of $10 million last year. I believe, right? I believe that this is the best, cryptocurrency there is. I don't know. I believe, right? So can I just prefix any statement with I believe and thereby escape liability? What does Omnicare tell us? Yeah, Andrew.
That a statement of belief is not a statement, but it could be liable for possible issues. You have to give some reason for that belief to have an investor make use of their statement of belief.
Well, right. So before we get there, what's the first? So the framework for analyzing opinion, or I believe statements, is opinion. You start with the premise that opinion is not fact, right? That's the starting point. Opinions are not fact. And Section 11 concerns facts. Now, there could be facts implied in opinions. Okay, that's the language that we see in Omnicare, that there's a certain implication of your opinion. Your opinion either assumes certain facts or implies certain facts. What's one fact that's implied by every opinion, the court points out? Yes? Same, right? Yes. Yeah. So fact number one is that you actually hold the belief that you say you do. So there's always a claim of sort of bad faith under Omnicare, right? You can kind of always say, suppose the corporate minutes reveal that the firm wrote, I believe, but the minutes of the board of directors, let's say, but in fact, all directors were sure that the statement was false. So I believe we have, patentable IP, but every director at the meeting says there's no way our IP is patentable. Right? Now you can imagine like an exam hypo or even a real life question where that line is really blurry. So it could be that some members of the board of directors don't think it's true. And then the question is, does the speaker actually hold that belief? So if we look, this is on page 998 of the casebook. The CEO's statement about product quality, I believe RTVs have the highest resolution available on the market, would be an untrue statement of fact, namely the fact of her own belief if she knew her company's TVs only placed second. Okay? Again, what about, a board or multiple people or a disagreement? Those are tougher, fun questions. All right? So that's one fact implied by a belief. What's another one? Well, as Andrew told us, that there can be some sort of embedded statement of fact. Right? So this is really what Omnicare is about. So on page 1000 of the casebook, Omnicare takes its point too far because a reasonable investor may, depending on the circumstances, understand an opinion statement to convey facts about how the speaker has formed that opinion. Or otherwise put, about the speaker's basis for holding that view. And if the real facts are otherwise, but not provided, the opinion statement will mislead its audience. Consider an unadorned statement of opinion about legal compliance. We believe our conduct is lawful. If the issuer makes that statement without having consulted a lawyer, it could be misleadingly incomplete. That's an interesting one, right? Think about that. So I believe I am healthy, but I have not consulted a doctor. seems to be, under Omnicare, grounds for securities fraud liability. What if, a firm says, we believe our hiring practices are, consistent with industry standard or promote anti-discrimination norms, but they haven't conducted an analysis of their hiring practices. There's no statistical data underlying that statement. This is kind of fun, right? So Omnicare is the stuff of exams, right? I mean, this is like, you can sort of imagine like all these sort of in-between cases. So that's if the issuer made the statement the paragraph says in the face of its lawyer's contrary advice, or with knowledge that the federal government was taking the opposite view, the investor, again, has cause to complain. He expects not just that the issuer believes the opinion, however irrationally, but that it fairly aligns with the information in the issuer's possession at that time. Thus, if a registration statement omits material facts about the issuer's inquiry to or knowledge concerning a statement of opinion, then Section 11's omissions clause creates liability. Does everyone understand the analysis thus far? Some of you have this puzzled look on your face. Let's make sure this is clear. All right? So prong one of Omnicare. You got to authentically, fact one that's implied is that you authentically, genuinely, subjectively believe the opinion. Evidence to the contrary, grounds for liability under Section 11. You all with me? You have an opinion. Question one, did you authentically believe the opinion? Evidence to the contrary, big problem. Prong two. Prong two, an implied fact about how you formed that opinion is like the absence of contrary evidence, or some sort of basis for forming that opinion. So we're going to read into your opinion a fact. The fact is, I formed this opinion on the basis of something reasonable. Like we comply with the law. I formed that, I believe we comply with the law. You never say we comply with the law, right? I believe we comply with the law. Everyone see why you would never say we comply with the law. That's a misstatement the moment you get a lawsuit, right? You lose a lawsuit. So I believe we're complying with all applicable statutes and regulations and that our conduct is lawful, whatever. I believe this. Implied fact, I've consulted with a lawyer. So these implied facts can be fun. You have to think creatively. An opinion statement, the court explains at the bottom, is not necessarily misleading when an issuer knows but fails to disclose some fact cutting the other way. Oh, so just when you thought that was the end, there's yet another, prong. Reasonable investors understand that opinions sometimes rest on a weighing of competing facts. Blah, blah, blah. A reasonable investor does not expect that every fact supports its opinion. In other words, this doesn't mean anything. I mean, there could be, just pick your paragraph. Moreover, whether an omission makes an expression of opinion misleading always depends on context. So, my statement, I believe we comply with the law, implies that I've consulted with a lawyer, but I don't have to disclose that some lawyers disagree, and I may not have to disclose that that most lawyers disagree if I am Donald Trump, right? Because then the context might create an assumption in investors' minds that, in fact, when I say lawful, I actually mean the subject of substantial and extensive litigation, but by and large still out of jail, right? So in other words, you can really just kind of read the facts into these buckets however you want. And just in case you were uneasy with that, the court reminds us that this is the case of the common law too. These principles are in the common law tort of misrepresentation, which is equally vague and unclear. But nonetheless, these are the contours of the doctrine. Omnicare, in the middle of the last paragraph, and this is what's bothering the court, would nullify the statutory requirement for sentences to not mislead investors by starting with the phrases we believe or we think, and the court is concerned about magic words and punching a hole in the statute for half-truths in the form of opinion statements. Of course, we all are concerned about that. That's not the point. The point is where you draw the line, is completely unclear from this, right? I mean, so what is the context? What does the context implicate or require? Notice again, I'm just going to keep drilling these themes in the last 3 minutes of class. This is all empirical, right? These are empirical claims. What folks in this context would assume investors know is actually testable and measurable. You go and ask them, when you see a company like this, what do you think? Do you think they have a lot of litigation risk? Do you think the opinion implies the following facts? You could conduct a survey. But no, that's not what happens, right? The court is normatively using those categories to just decide certain kinds of disclosures, opinion statements, need additional facts, and others don't. And so just going to, at the very tail end of our CLE-like class for today, just remind you that why it's really important to have a theoretical framework is because at the end of the day, you're going to fall into these kinds of open-ended tests like in Omnicare, where you're going to have to look at what's implied and what might not have to be disclosed because it's implied, but it's not rising to the level of something that's implied, that's not true, that's prong 2. And then finally, the context might completely change what those prior 2 tests lead to, as far as it concluded. So you have this very open-ended framework. I would encourage you to think how Omnicare maps on to the trade-off between disclosure and informed trading. Again, someone out there knows whether those opinions are true or not. And if we say that they've satisfied their disclosure burden by providing a statement of opinion, therefore, if you know something about the fact that may undermine the inference from the opinion, you can trade on that knowledge. That is by kosherizing the disclosure, by saying it is in fact just fine that you only give this opinion and say nothing more. By allowing the half-truth to emerge without more, you might be preferring a kind of informed trading of a particular kind. Right? And this bothers the Supreme Court. That's the point of punching a hole in the Section 11 liability that Kagan, I believe it is, creatively writes. That's what's bothering the court, because there's a sense that someone knows if the lawyer has told you that your business is not, in fact, lawful, and they're going to trade on that. But that has to be balanced against the concerns we've been articulating since Texas Gulf. Just put the firm on loudspeaker. How many dissenting opinions are needed until investors are going to get it right more than they're going to get it wrong as a result of that new information? That's the policy question, right? The real question is how many dissenting voices to an opinion need to be out there. And the answer to that question isn't really resolved by Omnicare, really, at the end of the day. There's just a framework for asking 3 different questions in a brief or on an exam or something. But at the end of the day, it's really about that choice. It's a policy choice. It's just a policy choice. Do we want more dissenting opinions out there? And you might think that for some opinions, more dissent is good. In other opinions, more contrary facts are bad. And that's really the question we want to be focusing on. All right? So, with that policy-ish end to Section 11, on Tuesday, we'll resume some more vegetables here. We'll dive into Section 12, A1, 12, A2. We will look briefly at, I think it's Section 18 or 17, and we will, thank you, and we will start to make our way out of liability into the much more interesting question of what is a security. It's like many of you are writing notes on whether Bitcoin is a security or crypto derivatives or Ethereum or smart contracts. So that's going to happen next week and into the following before spring break. All right, have a great weekend.
And then you'll be applying to the like, oh, by the way, here's the link or whatever.